Hello, everyone. Good afternoon, and welcome to this fourth panel of today's European Data Protection Summit. In the trap of reactiveness, can data protection be in the driver's seat? So for those of you who don't know me, my name is Anna Kolaps. I work in the cabinet of the supervisor at the DPS, and I'll be the moderator of this great session. I'm joined by the excellent speakers of today's panel. So this panel aims to unveil if and data protection, if and how data protection and privacy can be in the driving seat to shape our future, how the posture of privacy and data protection authorities is adapting in an age of cross-sectoral regulation, and lastly, if and how the public powers have a role to play in rebalancing power asymmetries while taking into account other imperative and compelling societal aspects. So I'd like to introduce you to the panelists, to the speakers. From my left, Dr. Johnny Ryan is the director of Enforce of the Irish Council for Civil Liberties. Johnny is also a senior fellow at the Open Markets Institute. His work focuses on surveillance, data rights, competition, antitrust, and privacy. He was previously Chief Policy Officer at Brave. Thank you very much, Johnny, for being with us today. Dr. Gabriella Zanfir Fortuna is Vice President for Privacy at the Future of Privacy Forum, where she leads the work on global privacy and data protection. Among others, a former EDPS colleague and, despite having crossed the ocean, a renowned expert of GDPR and European data protection law. Further down the line, Professor Ulrich Kelber, thank you, Gabriella, by the way, for being with us, for accepting. Ulrich Kelber has been the Federal German Data Protection Commissioner since January 2019, previously member of the Bundestag and Parliamentary State Secretary at the Federal Ministry of Justice and Consumer Protection. Thank you very much, too, for being with us today. Mr. Axel Voss was planned to be with us today. Unfortunately, had a last-second impediment, and he can't make it. So I suggest we go straight to the panel discussion. It is my intention to allow for a decent time for questions. So please, while we discuss these topics with the speakers, have a think about what could potentially interest you as a follow-up conversation. So the DPS, I think we really conceived the DPS anniversary that we celebrate today as a moment to reflect together on what has been the role of privacy and data protection in making society a better place and in protecting people, of course. But as the title of this session suggests already, some have argued that privacy and data protection, actually data protection already as a discipline and GDPR specifically as a legal instrument brings some reactiveness feature already. Equally, reactiveness is also one of the main criticisms addressed to data protection authorities who are said to intervene too late in the process when the harm perhaps is already realized in our world. So I have a first horizontal question for all the speakers. And the question is, does data protection and privacy do they have a reactiveness problem? And I'd like to start perhaps with Gabriella as EDPS colleague. Gabriella was already a renowned expert and a point of reference in EDPS when I was still moving my first steps in there. So Gabriella, do you think that data protection is merely reactive? Do you see a problem there?
Thank you so much, Anna, for the question. And I would like to start, first of all, by wishing happy anniversary to the European Data Protection Supervisor and to congratulate all of the colleagues, former colleagues of mine, of yours in the EDPS, and everyone that worked for the institution. which also played a very active and very valuable role in bridging the transatlantic privacy data protection debate. So happy anniversary. As to the question that you are asking, I have to say that as a very, very big data protection advocate, I am always trying to see the good side, let's say, the effective side, the valuable side in data protection. So to this particular question, I would say that data protection per se does not necessarily have a reactiveness problem. Because when I'm thinking of reactiveness and the other side of the coin, proactiveness, I'm thinking in several layers of this topic. And the first one that comes to mind is the layer of the substantive law and what do we have as obligations and what's on substance in the provisions of the GDPR, but overall data protection law. And when we think about it, if we actually look at it and understand it, it has a lot of ex-ante mechanisms put in place to be able to prevent unlawful behavior, of course, but also harm to rights, individual rights and to society as a whole. If we start with the principles and we understand that even before touching data, even before collecting, we need to have a lawful ground for processing, right? That's a sign of a proactive type of thinking that one needs to do before even deciding on how much data they need to collect and so forth. But more than that, what the GDPR did was that it brought this layer of accountability obligations that are very significant with the very, very big condition that they are actually applied, of course, and that we see them in practice. So we have data protection by design now, which is not a slogan. It is a legal requirement. It is an obligation. And it's not at all a reactive type of tool. It's supposed to be an ex-ante type of tool, and it's supposed to be a tool that's embedded into products, I would even dare say into business models. So when I'm thinking of the substance of data protection law and looking at this as a first layer in this debate, I think that data protection can absolutely be in the driver's seat. But then, of course, we have to ask ourselves, why does it feel otherwise? And then there are various reasons, and perhaps we'll discuss more in the panel later. So it might be that those who have to apply the obligations don't apply them. That might be one of the reasons, but at the same time, I'm also seeing some change that obligations like data protection by design, data protection impact assessments brought in some of the behavior of controllers or processors. For instance, I'm seeing more and more privacy lawyers being hired in product development teams of various private companies, which means that at least there is an intention somewhere out there to embed privacy safeguards into products. And then, of course, we can also discuss about enforcement, and I know that this was technically the driver of setting up this particular question. And I'm very eager to hear Johnny's input on this one in particular. What I can say from where I stand is that regulators can indeed be both reactive and proactive. Is it that bad they're reactive? I think regulators have to react whenever unlawful conduct happens. I think it would be bad if they would not react from that point of view, but they would need to react in an effective manner and in a timely manner, perhaps, and also to prevent further harm, new harm, further unlawful conduct, and so forth. if we're thinking about what a proactive regulator would look like, I think that's the very interesting question, and I would love to hear some thoughts on that. Is that a regulator who engages a lot with the entities that are being regulated in terms of giving guidelines, explaining, doing everything possible to prevent unlawful conduct and to prevent harm before it happens? Is it a regulator that starts its own volition inquiries, and that's perhaps another aspect of a proactive regulator, but then it would intervene primarily when harm has already happened. So I will stop here with the first round of comments, and looking forward to the discussion.
Thanks so much, Gabriella. So if a problem of reactiveness exists, let's say it's not necessarily the product or the outcome of how the norms of data protections law or GDPR are framed or crafted, if I well understand. I was I'm especially reflecting on some reference to own initiative inquiries and guidelines from data protection authorities in conducting their enforcement. Maybe that could inform a proactive enforcement. On this basis, I'll like to turn to Ulrich. From your perspective, which is of course one of the application of the laws, do you share this assessment? Would you first of all agree with the concept of this panel that there might be a reactiveness problem? And again, following what Gabriella just commented on, in case it exists, this problem, is it the result of substantial provisions or if something completely qualitatively different? Over to you, Ulrich. Thank you very much.
Yeah, thank you for having me. So there are core elements of data protection which by nature leads to a reactive role. Complaint handling, investigations following data breaches. But they are an important part of the work of DPAs and they have to stay. So reactiveness is not a problem and not a trap for itself, but it could become a problem and could become a trap if you are limited to this reactive role. And so DPAs should strengthen their proactive role with a courage for fast and enforcement to create blueprints for strategic controls and investigations to establish a compliance culture among controllers, being active in any lawmaking process, if invited or not. Be connected with society and civil society and science. Give guidance to important questions as soon as possible with papers, with juror fixes, with media presence. And my most important point for myself as an IT guy, do not wait for emerging technologies to come to the market, but try to give your recommendations as early as possible. We try to do this through different paths, and one of that is the Berlin Group, the International Working Group on Data Protection and Technology, which had its 73rd meeting the last 2 days in Oslo. And we are trying to pick emerging technologies and give recommendations to vendors, to lawmakers, to regulators, to users in that early stage. We learned something from the EDPS in that part, so the tech radar, and we brought that tech radar thing to a kind of a future foresight, so even earlier adoption to that questions. And this would really give an active role to DPAs. And if anybody is in the room who is interested in that from a DPA or civil society organization, in the next half year, there will be the 74th meeting of the Berlin Group, and you're invited to join.
Thank you very much, Ulrich, for this comment. So reactiveness, proactiveness, two sides of the same coin, the two pertaining in a way to the faces and posture of data protections, but reactiveness side to be reinforced, well, proactiveness side to be reinforced, as I understand in your words. Thank you very much also for reference to EDPS work, which I'm sure colleagues in the audience will appreciate. Johnny, you're leading important work on the ground building cases for protecting people. Are you happy with the current setting? Would you say that data protection is proactive enough?
I mean, I will defer to Ulrich on that question. I think what's going to matter over the next 5 years under the new mandate is that data protection be strategically responsive. Of course, you have to be proactive, obviously. When we got waves of consent spam in 2017 and 2018, and no one lifted a finger to correct the law firms who were advising the MailChimps of the world, I think we all should have learned that early intervention is necessary, and we're still fighting consent cases now. But let's just think about this idea of strategic responsiveness. We now have a pretty good picture of what the focus of the next mandate will be for the Commission. It will be about competitiveness, the economy. It will be about security and defense and safety, including integrity of elections. And it will also inevitably be about child safety in the sense of self-loathing, self-harm, suicide being pushed into kids' feeds. Now, those are 3 big problems to chew out. Now, let's just take one of them. If you think about where we are now, it's a real pity that Axel is sick today. I hope he feels better soon. If he were here, I'm sure he would say something along the lines of, the GDPR as it currently is the terror and scourge of small business. And I would say, Axel, you are absolutely correct. We now live in a world where when my children, when their photographs come home from school with their classmates, all of the other faces have smiley faces put on top of them. So we've got utmost concern on the part of the smallest players in the economy and in society, and we've got, nothing happening above. So if you think of in financial services, you've got the DORA legislation. You fix the problem at the top and it trickles down with regulatory effect because you've changed the system that everyone else relies on. And that's what we don't have. So thinking about the economy as an area of focus, we will see in the next days and weeks an agenda emerge about how we become competitive, this sense that Europe can recover space that it has lost between itself and America and China. And we'll hear lots of discussion of industrial policy, investment in digital infrastructure, maybe even digital infrastructure that is public in some cases, and the stimulation of innovation. Now, what we also need to hear is what can enable those things. I have worked for several very innovative startups, and the last job I had, I worked for the guy who invented JavaScript in a company called Brave. Brave is a great product, better than the competition, and I saw how painfully difficult it is to get every new member, every new user. It's so difficult because the incumbents, the big players who have swallowed up every digital market, have an internal free-for-all of data, and in many cases an external one that has been completely not enforced against. So the lesson I've taken from my experience is the best, if Europe can produce it, will not win. And the second leg of the competitiveness agenda has to be asserting European values that create space in the market for better alternatives to emerge. It's the same with security. You cannot have European and national security unless we have, if the Netherlands enforcer is in the room, unless they are going after Hikvision, for example, or if we still have a real-time bidding free-for-all after so many years. So if we're thinking about strategic responsiveness to what people's needs actually are, we're not going to be, telling schools, put stickers on, children's faces. We're going to be saying you intervene in strategic cases that have the most consequence for everyone. And I suspect this is something that can align with where the machine as a whole needs to go.
Thank you, Johnny. Now I'm concerned because in a way you made a great spoiler of my final question. So I hope you had good material to tackle that one later, but you're tackling on something which resonates with me a lot, talking about strategic responsiveness and strategic approach to it, with which cases that might actually have the most crucial impacts on our societies, as I understand. This was not planned, but I would like to perhaps give the other speakers the opportunity perhaps to react to this final point in particular, which at least triggered my attention in case of interest. Ulrich, I think you want to say something. Yeah, please go ahead.
There's always a risk for that, what Johnny said, that the more simple cases of private persons, of small associations, of small and medium-sized enterprises are handled first by DPAs. And I know the numbers Johnny and Max published by one country of the European Union, where a lot of smaller things happened and the large cases took some years before the first came to decision. But that's not the whole picture. So in a DPA, we are trying to distribute our resources not for quick wins by deciding on as many complaints or as many data breaches as possible, but to react on those which are candidate for blueprints. So if we decide one thing, then we have the blueprint for others. And most times, these are not the cases of the bakery around the corner, but this is the data handling of the large telecommunication, the large tech giants. And if we once decided there and got it through the courts, then there is no one other really, the most of the others take that as a kind of compliance culture. So this is my impression how most DPAs work.
Thank you, Ulrich. Gabriela, would you?
I would add that that is the beauty and complexity of fundamental rights. You know, they apply to the smallest of the individual to the biggest of the individual in terms of the rights that need to be protected. But I think that everyone is in agreement, a scale of strategic interventions is needed. And we already see something happening with the digital strategy package of the European Commission, right, which has new laws that are scaled in the way that Johnny kind of hinted towards, because we have the Digital Services Act that places enhanced obligations on very large online platforms, very large search engines. We have the Digital Markets Act that places its obligations on gatekeepers, again, very big players. So I think we're starting to see that in the regulatory space, at least, and not only in Europe, I would add. Very recently, I saw that Japan passed something akin to the DMA. So we're seeing this this idea of scalability of the regulatory activity spreading a bit.
Go ahead.
And very briefly to come back, an example of that kind of case that I'm thinking of, something that makes me feel quite optimistic for the future is, and it's not really a decision, but that change we saw in Meta's policy very, very recently. Right? So, you know, NOIP had a role, many DPAs had a role, and the DPC led in that, you know, that step where they had to say to Meta, you need to pause scraping everyone's Facebook accounts, and you need to reconsider this, and we have to see what comes next. But that's the kind of thing we needed to see half a decade ago. And if we had seen it, the next, you know, Clearview or whoever it is might not have emerged in the way that they did. So you're forestalling a wave of bad actors by intervening early. And it's very good to see that kind of thing finally happening.
That would be for you the proactiveness at its best, like impeding.
It was good.
I'd like just to, I was reflecting on what Gabriela just referred to in terms of scalability and scalable approach in recent acts emanating from Europe, the DMA in particular, and perhaps had Mr. Axel Voss been here, we would have been discussing also some relatively different aspect, but very much linked to this one, which is about, okay, what is happening to the substance of data protection law. So had it been here, perhaps you will have made a comment in this sense, or I anticipate. So I'd like to ask you, again, not foreseen, so you would forgive me for me daring to do this, but would you see any evolution in the near future, any in that sense, along the lines of what Gabriela, perhaps you want to take the floor as first, of scalable approach following what the new acts have been pursuing in Europe? Gabriel, you're not sure.
Because I'm not sure I understood the question. The first understanding I had of what you asked was whether there is a foreseeable evolution of data protection on substance in this sense of scalability. But then I don't think this is what you were asking.
No. Now I'm asking a different thing. Like would you expect like an evolution of GDPR? Well, let's talk the elephant in the room.
Yes, you're right. It's like the word that should not be said, right?
And we dare, yeah.
Yes. Well, I'm not sure about the GDPR itself as a legal act, but what I can say with certainty is that data protection law has evolved since the late 60s, early 70s. It was never meant to be set in stone. It appeared as a new type of law at a time where automation and computing started to become a thing. And it had waves of evolution, right? Core principles remained the same, but then they started to be enhanced, shaped, additional layers like accountability, the thing I mentioned earlier, started to appear as legal obligations. We had things like privacy by design, data protection by design added to the mix. So frankly, data protection, it was not meant to be set in stone. It was meant to be an evolving field of law, like any field of law. I think with the exception of inheritance, where we have institutions from Roman law that are still, alive and kicking, law always evolves. So I can imagine that data protection law will continue to evolve as well.
Quick reaction, Ulrich, Johnny, and then we move on.
The European Union Digital Acts means a big pressure on the evolution of the supervisory authority and the enforcement of the GDPR, of their horizontal orientation, of the overlapping, of the interpretation on the several parts of that digital acts. For the supervisory authority, there will be the question of, are there natural candidates for some of the additional regulatory acts, and how do this interconnect with the work they've already done with the GDPR? Developments, even technological developments, mean something to GDPR. How to interpret and how to enforce principles like core principles like purpose limitation in the AI time. Is it exactly the same like other technologies, or must there be another interpretation? And yes, and there's some shortcomings we see in our work where we like to see some evolution of the GDPR, producer liability, a legal base for profile building, not only for using the data out of profiles. And I think as not to leave the DPAs alone in the field, but to strengthen the possibility for civil society associations to go to court. So that would be some of the developments we need. And to the scalability approach, I think we can lighter the weight for some of the small and medium-sized companies in the documentation and information part. So that would be parts of that evolution, to be always going with the time and being proactive.
Thanks, Ulrich. Johnny, quick and sweet and short.
I take it a little bit differently. I feel like we're only beginning this journey. And it's not, I don't measure that in passage of time. I measure it in how bad is the situation. We are just beginning to think about applying this body of law. That sounds like a crazy thing probably to most people in the room, but you know, if you have used the internet recently, you will know it to be true. So in that context, I don't think we need to be changing the text in any way. I don't think we need to be doing anything complicated just yet. We need to do the basics. And in many cases, what needs to change for the basics to happen, it may well be, is a change in the posture of the Commission. You know, we point fingers at member states, but that's a total waste of time. It is the Commission's job to be aware of what the member states are or are not doing with regard to their obligations. They have to monitor very carefully. That has been an issue recently. And then, where there's a problem, they have to make a decision. Now, that decision is a political decision. That's the way it's set up. But I think in the coming mandate, that decision should be a little bit more assertive and ready and come from the very top, because actually it's compatible with strategic objectives.
Thanks, Johnny. I'd like perhaps to move to a slightly different topic, which I know is very dear to ADPS and many other people here, and what will mean for privacy and data protection authorities to be reactive. We are trying to also tackle, right, the topic of this panel, reactive, especially in such a complex scenario of multiple digital regulations. As you know, the DPS has been quite vocal since 2013, first with Peter Hastings, then Giovanni Buttarelli, and then the work we've done with Christian Giacuna on the Digital Clearinghouse on making and building a case for a coherent enforcement of laws between privacy, data protection, competition, and other authorities. So I was wondering whether you think this reactiveness problem could actually make it worse in the current setting, or is there hope for this dialogue to actually make data protection authorities more proactive? And I'd like to start with you, Ulrich. Germany is the country from where a crucial ruling of the ECJ, the European Court of Justice, originated. The famous Bundeskartellamt case, the Federal Cartel Office, with which I know you well cooperate. Actually, the ruling recognizes, incentivizes, actually requires a strong cooperation between, strong and sincere cooperation between authorities, applying principles of data protection laws to a competition case. So how do you see the evolution of data protection tasks in this respect? Does anything need to change? What about possible joint actions?
So we are now in our 47th year of our existence as authority. We see some changes in that time, and there are a lot of changes coming towards us. And as I said, as a result of the digital rulebook of the European Union, and the DPAs has to ask themselves and then to convince the lawmakers where their role is in the additional regulation. I see such a natural role, especially at the Artificial Intelligence Act, because it's so closely connected. But at the end, this will not all go to the DPAs for good reasons. And so the cooperation with others will be becoming a bigger part of our work, and a bigger part even of the being proactive in a way of having a common understanding of the roles, of the positions, and of the enforcement work that has to be done. You told that we have some experience with the not only some experience, but also some success story with the cooperation with the Federal Cartel Office. on their and our meter proceedings, not only on that one which was in the courts. And we took that as our crystallization point to create the digital cluster Bonn. So in the former capital, all the 6 major regulators and authorities of Germany has their headquarters. The mic is, that's again.
Working, yeah.
In Bonn, all these 6 major authorities and regulators for the digital part, for the rule book of the European Union, had the headquarters, and so we installed this digital cluster for creating a platform for inter-authority exchange, to develop a better understanding from the positions and tasks, to create synergies in knowledge management, in procedural setup, in internal digitalization. Yeah, if I use the word digitalization. I think this cooperation can be a part of the future of DPAs. You can even hold your independency, but getting much closer with others, because the tasks will be so complex in the area of the finance sector, of critical infrastructure. Some technologies which are now under the regulation of DPAs will be in the same time in the field of DMA, of AI Act, and it's not only for holding our own positions, but to give controllers and citizens not the need to speak with 5 authorities.
Thanks, Ulrich. I heard once one person saying that DPAs will have to either be ready to evolve in this scenario, or they will go extinct, they will die. Would you say that this is too much? Like, if you could quickly react to this, is this?
Wojciech used that phrase last year.
I don't want to say Wojciech.
And I clapped.
All right, thanks. Johnny, you were pointing in particular to things that need to be fixed in the posture of supervisory authorities, in particular. So I was wondering, how do you believe that digital regulators are cooperating to tackle together systemic issues? Is this going well? What is missing, if anything is missing? And is there, well, you hinted at that already, but is this technical? Is this political? Thank you.
I mean, I couldn't possibly comment, and I wouldn't know. But I can say that if we're looking for a model of how that can work, we look across the Atlantic. In the Biden administration, it's different for them because, of course, the agencies are led by political appointees, they aren't independent, and so forth. But there is this whole of government approach. It's a real thing. And they are working together horizontally in a way that we should all be taking note of, because they are much more effective together than they are apart. Now, I've had the feeling for years that when data protection fails to manifest, because it's not enforced, when it's absent, that puts much more of a burden on the adjacent enforcement community. So if you're a competition authority, you better pray that the data protection authorities have done their job so that problems don't reach you. And the same goes for anyone in the business of protecting many parts of public life and our society. And you can see it with media regulators and so forth. They are now being forced to grapple with things that are difficult for them, and sometimes they're in a contest for the same technical staff with the bodies who, by their inaction, let the problem fall down to them. So I'll give you an example. If we had applied purpose limitation robustly, DMA might not have needed it, right? Might not have needed large parts of it. And you could say the same thing for special category data and what that would do to the crisis we have with toxic recommender algorithms on social media. And of course, if you're thinking of cybersecurity and NIS, the absence of enforcement of the security principle in large parts of life creates a crisis for cybersecurity centers that they just don't need. So now we have this need for those parties to try and get involved in this thing that actually they shouldn't have needed to be involved in. And then they have to retroactively try and tie in the Data Protection Authority. Now, I'm saying it in a way that might sound a little bit odd, but what the court said in the Bundeskartellamt case is, if you can play well together, great. And if you can't, these people need to get out of the way. That's a terrible position for us to be in. And there was a phrase that popped up 14 times in that decision. I'm trying to remember what it was. It was something like concerns, or if there's a skepticism on the part of the Competition Authority about the Data Protection Authority. I wish I could remember it. So that's where we've arrived. I don't think we should be getting too preoccupied with building new structures. It would be great if they were built and worked. We need to actually think about how each agency does the basics, because if the data protection authorities did the basics, maybe there would be a much lesser burden on everyone else and there'd be less need for cooperation.
So the whole of government approach for Europe in a substantial way, is that what you meant?
In an ideal world, the next mandate comes in and says, okay, we have built an incredible regulatory toolkit and we have told the world we're going to be the rule setters. And that's not as credible now as it was when the last commission came in, right? Lots of new law, not a lot of the law looking real. And we need to fix that. And we need to fix it for all of the strategic concerns that are going to dominate the top table. And to fix that, what probably needs to happen is some political coherence that the Commission needs to lead, where you've got AVMSD at national level, DSA where useful, it can't take over everything, DMA, Article 101, 102 on competition stuff, Platform Workers Directive, all of these things. And insofar as possible, the political will to make sure that member state authorities, whether it's on GDPR or AVMSD, are doing are doing what's in their mandate through their independence.
Pretty clear. Thanks, Johnny. I'd like to turn to Gabriella, perhaps for a more centered question on AI. I was wondering, Gabriella, if you could comment perhaps on how would you see this reactiveness, proactiveness aspect perhaps changing in the ages of AI, and if you could comment also on how would you see data protection authorities in this. I mean, we've been saying this since quite some time. Data protection authorities have been applying laws to AI already. So what's changing? What will change? How would you see all this? Thanks.
Well, first of all, I would say that data protection authorities already are AI regulators. And that's just because a lot of the AI systems involve processing of personal data. Not all, and everybody is aware that, of course, there are AI systems built with industrial data, weather data, and other data that is not immediately personal. But because processing of personal data is involved in much of the life cycle of an AI system, data protection authorities, rather, even if they like it or not, they already are AI regulators, and they have to apply the rules of the GDPR to the development of AI systems. So I continue seeing a role of data protection even in this new age of AI. I think that is very clear. And hopefully we'll start seeing a bit more activity in that space.
Thanks, Gabriela. Unless reactions, I'll perhaps move to my final round of questions, which is, again, very similar to all of you, because I like to get back, and then again, we take questions from the floor, but very quickly, I'd like to get back to the topic of this conference, which is about democracy. I was especially personally glad that the concept of power really came through several sessions of this summit. And I think this is a very important development, which perhaps would have been just not conceivable in a setting like this only a few years ago. Especially the first part of this conference was focusing on the public dimension of power, encapsulated in the role of states and governments. But we often observe a too big imbalance of power and means, including financial means, in our digital landscape, especially in the face of very few private powers which have grown bigger than states in some instances, with people feeling neglected by public powers instead in the struggle to affirm their fundamental rights. So my question, perhaps a fundamental question to conclude this panel on, is whether you think that public power should rebalance this asymmetry of power in support of individuals. And would it be fair to say that reactiveness, in a way, is also trapping states, so not just possibly data protection authorities, but states as such, who should be placing privacy and data protection in a broader setting, in a broader space, which includes also geopolitical aspects, security in privacy being instrumental to security, and competitiveness. Johnny, you touched upon on that already. So I'll actually want to start with you.
So, I mean, the starting position is, of course, fundamental rights, but these other things have to enter the frame. And I think it was Helge Eimans, when he was at the EDPS, who was starting, I mean, many years ago, right? I think I'm right, to look at this this market power aspect. Certainly it was something Giovanni Bottarelli was interested in. And, you know, there are very practical concerns there. We still don't know if DG Comp, for example, when it's making a merger decision or an acquisition decision, we still don't know, and we can assume that it doesn't, that it requests a ROPA from both parties to try to hypothesize what might happen when they are merged. So, you know, Google buys Fitbit. The remedy is Fitbit's not allowed to use, Google's not allowed to use Fitbit data for advertising. I mean, maybe they want to get into insurance. So we don't even know, actually, if there would be such a thing as a sufficiently granular ROPA for them to make that kind of evaluation. So I see the need to bring these things together, absolutely. But on the question of asymmetry, I think the outgoing Commission on Data Protection, I don't think it has done itself and us a service. If you think about the proposal for a procedural harmonization, that proposal, I was really dismayed when I read it. I'm just looking through my notes. It shifts the balance decisively in favor of the party that is the subject of a complaint. TikTok, Meta, these people apparently need the balance shifted in their favor. And the complainant is frozen largely out of the process. No access to the file, which is a remarkable thing. Now, this presupposes that in some cases, maybe the authority has better technical expertise than the complainant. But in these cases, that may not always be the case. And the posture shown by that proposal, I wouldn't call it a deference to the controller, but the change in the power dynamic between a complainant as a party and a party under investigation, right, a defendant as a party, changing that into something else. I actually can't describe how surprising it was to me when I read that proposal, and it should be no surprise that the Parliament, you know, rewrote the thing, and that was inevitable. So I think we need to see in the next mandate quite a different approach taken to data protection, and a realization that this is not a problem to go away, not something to bury. This is something to use.
Thanks, Johnny. Gabriella, your views on this?
Perhaps just a very brief thought, because I'd love to hear some questions from the audience. I think it's now mainstream thought that we are talking about dynamics of power when we're thinking about data, personal data, and so forth. And I remember the novelty of those big data opinions from the EDPS back in 2013 and 2015, and then the novelty of the digital clearinghouse, and how important that was as a stepping stone to further the conversation this way. But I think now everybody understands. It's mainstream thought that we are dealing with a matter of imbalances of power. So I would just leave it at that.
Most people outside can't be experts on digital topics because they have to do different things in their life, but they feel that there is something wrong. They feel the outcome of capitalistic surveillance. They see the being locked in the services of some of the large tech giants. They comply about being manipulated or being transparent. By this data, which are in these data lakes or these data heaps, they are transparent and they are objects to manipulation. For a long time, parts of the politicians didn't see that private companies, which not have the same instruments like a government of fines, of repression, that you don't need to have the same possibilities to defend your civil rights against private companies like you have to defend them against unproportional governmental excess. But that has changed with that power of that companies. And so there must be a trust that we ensure the same independency of citizens toward large private companies than towards these unproportional excess of powers, access to data from governments. And that must be the next step for inside politics. And what I see back home that this understanding is quite not there. I hear a sentence like, why do you comply about that governmental access on that data? People give liberally all the data to Meta and Google. In one of the treaties of two coalition partners, so parties do have treaties for a coalition in Germany, and in Hesse, so the birth country of data protection, they really put a sentence in, we want to use all the standards which are there in the world. So that was not, we will support the data protection authorities to make them comply to European law, but that means shut up. We want to use Microsoft 365, we want to have Facebook fan pages, all that stuff. So as long as this is the message to citizens, then there is this imbalance being felt institutionally by people. And so if Axel would be here as one representative of active members of parliament, I would ask him that they always have to promote data protection as a tool for free and liberal societies, that they must not discredit data protection for a cheap win in a debate or to abuse it as an excuse. How many times I heard that? And the most and best thing is that they really understand that work of data protection as an anchor for trust in population for digitalization. And if that would be promoted, then there would be pressure on that large companies to have a real privacy sells attitude. That so to bring in privacy by design and security by design, not only by words, we need a word like greenwashing for that, but by real means to the products, even over achieving that what is given by law. But for that, we need a change in the attitude of some leading persons in politics, yes. And like Johnny said, there is a fight that there is not a fallback in the regulation for this idea, if anything goes attitude for digitalization. So yes, there is this imbalance, and people feel that there is this imbalance, and this is dangerous for a democracy.
Thank you. So as you said, next step, this is the next step for politics, right? Like,
to change that attitude. In every hearing I have in the national parliament, there is at least a part of them which are not willing to follow that rules, that principles they've once set by law, because they now want to have this certain digitalization, doing it the quickest and dirtiest way possible, and not seeing the very meaning, the basis out of a well-done digitalization, by a law-compliant digitalization, by a democracy-friendly digitalization for the society. And this will be a hard work.
Thanks a lot. I'll stop here for the panel discussion. It's not your turn, please. We open up the floor for questions. I think we can take at least two if the answer will be short, as I hope. Yeah.
Affiliate?
If you could please introduce yourselves.
My name is Kohei. I'm from Japan. I work in privacy by design. So I have a question to three of you. I love this topic because the reactiveness is not effective, because privacy by design is an included concept of proactive. It's very important to design a privacy. Of course, the GDPR has the by design and by default. So my question is, especially for the business guys and industry people who want to use the personal data, excluded of the privacy community, they are not aware the importance of the privacy by design, by default. So how we can make effective solutions to encourage them changing the behaviors to be a proactive? Maybe you work on many of the things, just enforcement is the one actions, but we have to consider, except for the enforcement, otherwise is just like the business people is disincentive for that. So could you share about your thoughts? What kind of the effective solution you have in mind?
Thank you. I just want to see if there is a second question over there. I think we can. I just want to hear the second, and then we tackle them jointly.
Hello, thank you very much to the panelists for very exciting and insightful discussions. My question relates to the relevance of data protection authorities during the implementation of the AI Act. So we've already heard that really GDPR, we're only the tip of the iceberg in terms of seeing the novel interpretations in connection with AI. But I wonder if the panelists had any insights they'd like to share as to whether or not data protection authorities would be suitable to be market surveillance authorities, so the main regulators under the AI Act.
All right, thank you. I think Johnny wanted to tackle the first.
Yeah, just on the industry question, I remember having these conversations internally and being asked, are the Europeans serious about this data protection stuff? And saying, yeah, I think this time they are. I was wrong. I was wrong. I was totally wrong. Now, the reason why a company does not need to know what the obligation is because there's no enforcement of the obligation, or at least very little. We hear depending on the authority you talk to, we hear an awful lot about guidance and turning up to events and speaking and blah, blah, blah. Enforcement is guidance, right? That's how you educate people. You educate the market by enforcing. You educate courts and judges by bringing cases. I mean, this is, every sensible enforcer that's been around for a long time knows this. So it is for companies to decide whether to respect and fear the enforcer, or even know who they are, even care. And that's happening less and less. They're still paying when they're big to sponsor events, but they care less and less. So the second thing to say is, on the market surveillance question, it would be wonderful if DPAs were suitable to be such an authority. I can't imagine who else might be, but I'm not saying that they are.
Would you like to take up one of the two questions, perhaps?
I would like to at least say hello to Kohei and thank you very much for that question, which goes to the points that I made very early on, that that there are such tools available to be proactive, and that organizations that have the obligation to implement them play a very important role here. As for an effective solution, other than campaigns of informing and regulators engaging, even through guidelines, even though I understand that guidelines are not the favorite thing of all of us here on stage, at least, but I think they are important as well. And to Johnny's point, enforcement actions are also important. We have seen some little enforcement, but we have seen of Article 25 GDPR, and we actually published a report last year summarizing case law from data protection authorities here in Europe on data protection by design and by default. So I would say ranging from very solid enforcement to information campaigns, to targeted guidelines, something of this mix should be working.
With the first question, I agree with my both co-panelists, but I really see the role of enforcement even for privacy by design. And let me give you an example. There was a development of an electronic file system for human resource tasks in federal authorities. And when they were finished, starting it to enroll it, we found that there were so many non-compliant parts in it that we now pressed them to reprogram it. And this reprogramming is binding for years, part of their resources, and it will cost 5 times the original development costs. So with the next project this authority started, they were much earlier in contact with us. So good enforcement helps. AI, yes, I see the DPAs as the natural authorities in the AI Act. Why? First, all the AI systems which do not fall under the AI Act, the non-high-risk systems, almost all of them will only be regulated by data protection authorities in all the parts where they have personalized data. I mean, there's no other one for that, except the finance sector, but it's a very small one. And with the high-risk systems, in every time where the high-risk system has personalized data with it, that will be the biggest part, the DPAs will play a role. And now the question is, do you want to have 2 authorities? How do you will have the regulatory sandboxes? What will happen if 2 authorities will have a different position on the same question? So if you do not want to have bureaucratic overload, and if you want to have civil rights really be enforced even under the AI Act, then the DPAs are the natural candidate for that position.
Thank you so much. Before concluding, I'd like to see if there is a final burning question, and that would be in case just the final one, because I have colleagues already looking at me and urging me to stop. So is there a very final burning question that no one is daring to ask? No, no one is daring. So we stop for now. I think this discussions will definitely not stop here. At the very least, they will probably hopefully feed into at least the next panels next. We'll be discussing proposals and how to turn wishes into proposals. In the meantime, I'd like to thank the panelists, and please join me in thanking them with a big applause. Thank you so much.